Miss Zenda, she's like, oh God, what? No, you had a seat over there, and we had to move you because of what was happening this morning. You may go back there. I don't want you to feel as though you can. In fact, we've named it the Zenda chair. So, all right. So, yes, you can go up there. It was just for this morning. All right.
The atmosphere in Judge Simpson's courtroom starts with awkward humor. The so-called Zenda chair joke sets a strange tone for what's coming. But beneath that levity, the court is about to tackle serious matters of addiction, violations, and repeated chances. This is a classic Simpson setup. Calm entry, surgical precision to follow. When the clerk calls People v. Thomas Rochelle, the tension rises instantly. A man hoping for another shot at sobriety court, and a defense trying to convince the judge that redemption still outweighs the record. Viewers should note this early rhythm. Every courtroom drama builds in layers. Humanity first, legality second. And Judge Simpson, he never misses when testing both. Stay alert to the subtle cues, pauses, interjections, tone shifts. This is where mercy meets accountability. Who's about to win that balance? Keep watching. It's about to get tense.
Court calls case People versus Thomas Rascal.
Absolutely, for the people. Stephanie Shannon on behalf of Mr. Rascal, who's appearing to my right. Could you please state your name for the record?
Thomas Rascal.
Yes, you're requesting an adjournment.
Yes, Your Honor. So this case was adjourned previously for my client to interview with sobriety court. He has done so. He was not accepted, not because of, I'm sorry, I haven't even had the opportunity to tell him I got an email this morning. And I will go over the reasons with him why. I would like the opportunity to try and mitigate this down a bit. In the meantime, Your Honor, and my client would like to address bond.
Go ahead.
Your Honor, the reason for my client, he is actually a perfect candidate and a great candidate for sobriety court, but because of matters outside of this jurisdiction, older matters outside of this jurisdiction, he was not accepted into our sobriety court. My client wants to fight the warrant that brought him here. He wants to fight it. He gave me a backstory behind that. My client is not actually a threat to the community. He will be here for every court appearance that the court wants him to be here for. He just has a substance abuse problem. He is willing to be released into treatment if the court is inclined to do so. He was homeless. He just got a home. He's back in a home now. He has animals that he needs to take care of in that home. He's willing to be tethered there, Your Honor. We honestly thought that sobriety court was going to work for him.
Well, the problem is there's nothing in place and he's already violated the conditions of his bond previously, right?
Here, the turning point arrives early. The judge subtly reminds everyone that Thomas has already violated conditions before. That's not a random interjection. It's a legal flag. Repeat violators lose the presumption of rehabilitation. The defense scrambles to salvage credibility by mentioning a medical marijuana card, trying to shift a violation into lawful gray area. Classic defense pivot, redefine the breach as compliance through another lens. But Simpson cuts through with surgical logic. He's heard this song before. Substance abuse plus repeated violations equals risk profile, not redemption. This moment is key for viewers who follow court psychology. See how the judge dismantles emotional arguments with factual anchors. He doesn't yell, he just resets reality. Quiet authority often hits harder than courtroom theatrics.
Your Honor, my client, I'm getting it to the judge. Your Honor, my client, as far as, and I went over the bond violations with him. He's indicated that he has a medical marijuana card. And so there is that. If you are telling him that he can't smoke that, even with that.
I'm not saying he admitted to the violation.
Your Honor.
Your Honor. Okay. Your Honor, my client, again, he just has a substance abuse problem. If the court,
I understand that,
if the
but
treatment, he's fine with that.
Ms. Lundy,
The difficulty is at the time of this case when the defendant was stopped. It's my understanding that because he had a no bond bench warrant for a felony CCW out of Lafayette Village, so it's not just a substance abuse problem that seems to be going on here. There seems to be tangential things that are very concerning to the public. And we do have the issue with the violation here. I also show currently in X jail, we have 2 out-of-county holds. One for Battle Creek with a $200 bond for retail fraud, one out of Lansing for another retail fraud case for $868 bond. So the concern here is that if there is a PR, it's not going to be released. Likely, maybe will go to a different location or several locations in the state. I'm asking the court to continue the bond.
The prosecution enters like a scalpel, cold, organized, data-driven. 2 out-of-county holds, 1 retail fraud for $200, another for $868. These aren't massive crimes, but they destroy the defense narrative of a model candidate. The prosecutor reframes Thomas as a repeat offender, moving across jurisdictions. That's the kind of detail that makes judges tighten bonds. What's fascinating here is the contrast. Defense argues rehabilitation, prosecution argues pattern, and both are right in parts. Addiction does not erase criminal responsibility. Judge Simpson now faces the classic conflict, public safety versus personal struggle. Watch how he balances compassion and control. When prosecutors bring receipts, the tone of the courtroom changes from empathy to enforcement. The tension just spiked, and the defense feels it.
I haven't seen the denial, so I haven't seen why he didn't get treatment in court. But if it is as represented, I'm sure it will be, absolutely. As defense counsel saying, it's because of his other cases throughout the state. So that concerns the people and his ability to remain law-abiding bondholders.
Your Honor, he has no holds. I checked into it. There's no, let me say this, according to X jail, he is not being held for the CCW charge. They're not looking for him.
She's going to show you the holds before you make that representation to the
He
court.
has the two smaller ones, but not for the CCW.
Oh, 2 small holds.
I meant to say not
Those
for the CCW, Your Honor.
those, because they're small, they're not holds.
Yes.
Okay.
And they're really, really old charges, Your Honor, and my client wants to address those as well.
I know, because he didn't go take care of them. That's why they're old.
I
I was
understand.
in prison.
Thank you.
The defendant's sudden admission, "I was in prison," lands heavy. It strips away every attempt at soft framing by his attorney. Once that word drops, the entire energy in the room shifts. Simpson, always aware of optics and context, doesn't react emotionally. He recalibrates. To the audience, this is a raw look at courtroom truth. The record speaks louder than the rhetoric. The defense's earlier sympathy play collapses, replaced by silence and procedural formality. This is the moment that defines real-world justice, not what's said, but what history proves. It's a harsh pivot, but Simpson's court thrives on these resets. If you were in the judge's seat right now, would you still consider bond leniency, or has trust already expired?
Your Honor, we would just like to ask to be allowed out of bond.
Motion for bond reduction denied. Bond will continue. Thank you.
Assistant Public Defender Chelsea Vergils with and on behalf of Patsy Shear.
So you might want to check your other case that she has. Because you pled today on another case, right? Before Judge Freshour?
Yes.
And we were just informed that that was put on the 30th.
Okay, we'll ask to change both of them. Thank you.
All right, so I'm going to leave this as I said it. Bond will continue.
And may I address bond, Your Honor?
Sure.
Thank you. At the risk of redundancy, I would ask for consensual contact. She has now been out of inpatient treatment for a couple weeks, I believe, and is.
What'd they do on her other case?
She said that right now she is not allowing consensual contact, but she said that she would consider changing it before her sentencing if you allowed consensual contact.
Who said that?
Judge Freshour. I also.
No, she didn't have said that. Go ahead.
I also believe that the complaining witness is here today to ask for contact. Again, she's doing very well in her treatment and now resides at transitional housing, where she follows her other bond conditions successfully.
Your Honors, it was my understanding, or what I was told, is that Judge Freshour declined to address it until sentencing, so I'd ask that it remain in place until sentencing.
That sounds more like what I would think Judge Freshour would have said. Is that I can't see Judge Freshour having a DV, there being a DV hearing, saying, well, whatever the other judge does. I'm not.
That was my understanding, but I also
So here's what
understand.
we'll do. I'm going to deny your request to change that. And certainly, I'm sure Judge Freshour's next door. She'll be more than happy to hear you. I'm not changing it. It's all going to go before Judge Freshour. She can.
This is judicial boundary setting at its cleanest. Defense tries to reopen the issue of contact restrictions, possibly to soften bond conditions through emotional context. Simpson refuses, decisively. He honors jurisdictional protocol, directing the matter to Judge Freshour. It may seem procedural, but it's a masterclass in judicial discipline. A weaker judge might entertain re-litigation. Simpson won't. This keeps courts from devolving into emotional negotiation rooms. For anyone watching, take note. Restraint is power. By holding the line, Simpson preserves institutional order and reinforces credibility. The defense walks away unsatisfied, but the court stands intact. The audience should feel the calm authority here. No shouting, no drama, just total control.
Render a decision on that. All right. Thank you.
Thank you, Your Honor.
Can we address bond, Your Honor?
Have a shot. Go
Thank you,
ahead.
Judge. Judge, I'm sure that the court is familiar with Mr. Rainey. We've been back and forth. He is here today. He's taken responsibility for this. He was remanded at his last hearing due to the bond violation for him leaving the state of
Of
Michigan.
leaving the state of Michigan.
Yeah,
That's-
Yeah.
I'm from Indiana.
And
I'm sorry to hear that.
you're,
Go ahead.
Your Honor, we just really wanted to address the court and see if the court would be willing to give Mr. Rainey another opportunity. The court he was in custody for nearly 7 months before our last hearing when he was released. When he got out, he realized he had nothing, had lost his home, lost everything that he had. He had a grandmother who lived in Indiana. And when he came out of the jail, he was sitting outside for about 5 hours before he was finally picked up from someone. He stayed in Indiana just for 1 day, Your Honor. He did return back to Washington. He indicates to me now that he has a stable.
Well, he didn't return back to Washington.
This exchange captures a perfect blend of legal scrutiny and subtle humor. The defense tries to downplay a violation, framing it as a harmless one-day trip to Indiana. But Judge Simpson spots the weakness instantly. Leaving the state under bond supervision is not trivial. It's a breach of trust. The judge's dry retort, "I'm sorry to hear that," shows his style, precise sarcasm layered under authority. He doesn't raise his voice. He uses tone as a scalpel. The deeper point for viewers Simpson sees through framing devices. 1 day is still defiance. In legal psychology, minimizing misconduct often backfires, and that's exactly what happens here. Simpson's patience is tactical. It lures full admissions before dropping the procedural truth, the subtext. If you disrespect the court's boundaries, expect no sympathy.
Did he?
He did. He presented himself at the last hearing. He was remanded at that hearing. He wasn't picked up or
Right, but
arrested.
he didn't come right back to Washington. He
He-
was elsewhere in the state.
I see Litchfield, that is right.
Litchfield is in,
Yeah,
Mich-
'cause I-
oh, I'm sorry, not Washington, in Michigan. I apologize, Your Honor. He returned back to the state of Michigan. He indicated to me he was only gone to Indiana for 1 day. Even knowing that he had that bond violation, he has been very much so willing and ready to take responsibility and resolve this matter. He came to court, presented himself to the court, knowing that he would likely be remanded for that violation. He was in contact with community corrections. Since then, he had been testing for his other probation matter in Litchfield. Is it Litchfield?
Yes, let's
In-
be Hillsdale County,
In Hillsdale County, Your Honor. So
Where is he going to be residing?
which would be my actual grandmother's house. I'm staying there. She told me that if I stayed out of trouble, I'd be
But
able
you
to.
went to your grandmother's house in Indiana.
I have 2 grandmothers on both sides.
Okay, so it's another grandmother's house.
Yes,
You have verification of that?
I have spoken with her and I can get verification.
I need written verification and then I'll take a look at it, but at this time it's found, it's denied.
Absolutely, Your Honor. I'll get that over to the court.
You're gonna probably have to bring that to Judge Freshour.
The denial lands with surgical precision. Simpson gives the defense time to speak, then cuts through their narrative cleanly. His refusal isn't impulsive. It's structured around evidence and consistency. He requires written verification, not verbal promises. For the audience, this is legal discipline in action. Proof before persuasion. Many defendants misunderstand this. Emotion cannot override missing documentation. Simpson's denial is firm but not punitive. It's a teaching moment. Integrity in process outweighs convenience. The defense respectfully concedes, but the damage is done. Each denied moment reinforces the hierarchy of courtroom order. Watching this, you see how control and respect are enforced, not by volume but by certainty. This is how real justice stays grounded. Verifiable truth over convenient storytelling.
Thank you, Your Honor.
Also like to address bond if when appropriate.
Probable cause conference will be adjourned January 30th, 2025, 9 a.m. as to bond.
Yes, Your Honor. Talking to Mr. Hyman making me request a release on a tether. Mr. Hyman would be able to release to his father's address. He currently helps his father in taking care of him because his father does have some mobility issues after a car accident. Mr. Hyman has been consistently working. So at this time, I'd like to request a release on a PR bond, tether, or in the alternative, a reduction in the bond.
Ms. Phelps.
Rather than people to post production of bond, we originally requested 100,000 in this case, we're giving 50,000 for 10%. In this case, the difference is broken up, and he was at the victim's residence, was all bunch of beautiful car, they got into an argument, he slammed the victim's garage, pinned her by the chest. Get away from the defendant, go in her house and lock the door. He takes the door, it's a deadbolt, still locked. And they continued to argue. He then went and retrieved a shotgun, said, I got something for you, and cocked a gun, and completely denied this at arraignment. So people have concerns about public safety and would ask the court not to respond.
Anything else?
This section explodes into the real tension of the courtroom. A firearm mention. The phrase retrieved a shotgun instantly transforms this case from procedural to public safety territory. Everything changes. Simpson, who had been managing rehabilitation cases and bond issues, now faces a potential threat scenario. The prosecution brings forward details that carry weight, aggression, escalation, and risk. The defense still pushes for bond reduction, but this is no longer a moral appeal. It's a battle between risk perception and reform argument. For viewers, note how quickly the narrative shifts once violence enters the record. Judges pivot to protect the public first, then the individual. Simpson's eventual denial isn't just expected, it's inevitable. You can feel the courtroom's mood go cold. Law trumps empathy when a gun enters the story.
I was able to speak to Mr. Hyman's father, who is here this morning. He says he would be responsible for Mr. Hyman, and he has that support, so I would still request a reduction in bond.
Well, given the court does consider him a danger to the public, motion for bond reduction denied. Bond continues.
There's no changing of bond.
Judge, it's not a bond request. I just wanted to get clarification. He currently has 2 tethers on right now. I know the last time.
Really?
Last time we.
One on each leg?
One on each leg, Your Honor. He's running out of legs at this point.
Go ahead.
The last time we were here, we talked about possibility of removing the tether. He has been able to sign the release. I just wanted to know if the court would
Sign which release?
So there's a release from the community corrections in Eaton County to allow Washtenaw County to supervise him with the Eaton County tether. I wanted to know if that was sufficient to see about getting one of the tethers removed, specifically the Washtenaw.
No, what you just said didn't make much.
Okay.
That Washtenaw County would be supervising Eaton County's tether. They're the same type of tether.
Correct. They're both scram tethers.
Your Honor, if I may.
Yes, please.
At this point, the people would be opposed to any change in the bond conditions in this case. The BAC is a 0.237.
This part is pure judicial pragmatism. A blood alcohol content of 0.237 isn't just high, it's nearly triple the legal limit. That number alone defines the case. Defense attorneys often try to frame context, stress, trauma, medication, but numbers like that erase gray areas. Simpson knows it. The prosecution uses data to corner the argument, and it works. He refuses any bond condition changes, seeing the defendant as an active public risk. The defense attempts to humanize the man through caregiving to his injured father, but law doesn't negotiate with numbers. A back that high screams instability. For legal observers, this moment shows the hierarchy of courtroom influence: facts first, feelings second. Simpson's patience never wavers, but his decision is immediate. In one exchange, you see what justice looks like without emotion, purely empirical, perfectly reasoned.
So at this point, while he's still on bond in this case, before we know exactly I request the court to continue this tether. If we're able to get sufficient information from defense counsel in the meantime about how he's being supervised, I would consider skipping over if we can move on with the two of us, but right now, I would request that it just continues as is.
We'll get that information to everyone, Your Honor.
So you're withdrawing your request at this time.
At this time, Judge. Thank you.
Very good. Bond will continue.
Okay, thank you,
Thank you.
Judge.
Did you have methamphetamine in your possession?
Yes, sir.
Had you used it?
No, sir.
Were you about to use it?
Yes, sir.
All right. And did you know what you had in your possession was methamphetamine?
Yes, sir.
All right. I can take the plea certainly to the higher charge. Counsel, have I complied with the court ruling? Would it be proper to accept this defendant's plea?
People are satisfied.
Defense is satisfied.
Court will accept the defendant's plea to count two. Count one is dismissed. The pre-sentence investigation and report is ordered at 1482 probation. Sentencing in this matter will be
January 29th at 11 a.m. before Judge Barr.
January 29, 2025. Said 9.
11 a.m.
Oh, of course. 11 a.m. before Judge Barr.
Your Honor, regarding bond,
Yes.
he was remanded last week. He does want to get back to employment. He does work. He, I believe, fully understands what he things he was doing on bond by violating they weren't nice. And
Yes, sir. I apologize for defying the court and disrespecting the courtroom and disrespecting you and what the court is about.
Yeah.
He very educated. He went to U of M. He was in the Army National, or he was in the
U of M.
U of M. He was in the
That U of M?
Army National Guard.
And you said intelligent.
It's in Maryland.
You said Maryland? Okay, now I understand. Go ahead.
Supportive. I was
You're at a loss, Griffith. Didn't know where to go with that. All right, so if I let you back out, are you gonna start testing clean?
Yes, sir. I will be testing clean.
I don't need a form. Any response from the people?
Okay.
I'm going to inform Judge Barr that if there's a mess up, that I've given you this opportunity. Understand me, young man?
Yes, sir.
Yes, despite the fact he went to the wrong U of M. I'll reinstate his previous bond. Don't say anything, Lundy. I know you want to. What are we doing?
Your Honor, we are ready to set this for exam.
Okay, I don't necessarily have a problem. You see the new violation report.
Yes, Your Honor.
All right, what do you want to do about that?
Your Honor, he's acknowledging that he's in violation of his bond conditions. He does not have money for testing. He also doesn't have transportation for testing. Additionally, Your Honor, he has a medical condition that causes him to have great anxiety under those testing circumstances, and historically has not been able to provide specimens, even if he had transportation and money.
So basically,
Well, except that on December 18th, he was able to do so.
by force, basically, I had to force myself to do that along with the rest of the tests. The last time that I went to go drop and do my test, my kidneys hurt so bad, I almost felt like I was gonna pass out, basically. My body just wouldn't let me.
The tension here is quieter but equally sharp. The defendant's explanation, "My body just wouldn't let me test," might sound plausible to some, but to a seasoned judge like Simpson, it reads as non-compliance cloaked in excuse. The key detail: multiple missed tests, inconsistent timing, and last-minute calls. These are behavioral flags. Addiction courts see this pattern daily. Avoidance framed as incapacity. Simpson's analysis is forensic. He doesn't insult or accuse. He references data points. It's a pattern recognition response, not emotion. For viewers, this is where sympathy meets skepticism. The defendant insists sincerity. The judge sees repetition. This isn't cruelty. It's accountability fatigue. Courts can extend help repeatedly, but when patterns persist, even compassion hardens into consequence. This VO embodies the exhaustion of systemic leniency meeting chronic relapse.
Here's my problem. When I'm looking at this, this looks like somebody that just doesn't want to cooperate in the process. He tests, then telephones in right before Christmas saying they didn't have the money to test. Then the next two tests that are scheduled, he just misses. Then the next test, it's an enable or refuse.
I'm not trying to play. I'm sorry if it looks that way.
Your Honor, could the prosecutor and I approach?
You may. Record to reflect the defense conference in this case. What I'm going to do in this case is I'm going to adjourn your probable cause conference out, check into alternatives to how to resolve this case. Would February 6th or 13th be better for you, counsel?
February 13th is a good day, Your Honor.
All right. February 13th, 2025. I'll set it at 9, but you'll get an invite with the time. And then with reference to this testing, at this point, I'm not going to violate the defendant on the report. What I'm going to do is I'm going to switch his testing, and so you'll have to appear, and they're going to do a swab. Okay, I usually don't do that, but I'm going to do that in this case because I really want you to test. Got it?
Sure.
Okay. And so we'll sign that order. Is that?
Transportation.
My girlfriend said she'd take.
Oh, we're off, my bad.
Yeah. Got it. All right. So, and I don't know, you can check how many times he had it. So that order would be over there, and you may want to go over at this point. Do you know when your next test is supposed to be, or they
I
haven't
have
called you?
been able to figure out from what I knew it was supposed to be this week, and I tried to test and it wasn't able.
All right, so here's what I'm going to want you to do. Since you're here on this campus right now, I want you to go over and see if they can get a swab in today. That way to start it out, and we'll send over the order. Okay?
Thank you, Judge. And one last thing.
Yes.
He missed a court date this morning with Judge Freshour, and she
He
said
did.
that perhaps we could address that with you while we were here.
He missed it this morning with her.
Yes, sure. It's
Yeah.
a separate matter. It's a
Do you
mystery.
have a case number on it? Let's see.
Yes, I do. Your Honor.
Let's take a look and see what they did.
It's 24F41587FY. Oh, I'm sorry.
No, that's us.
I'm sorry. It's 2440331.
If they issued a warrant to cancel the warrant, get them reset, and give you a date. Or if at worst, give you the bond recall information and let you go through that process. But
Thank
let's
you
see
so
if we can
much.
shortcut that, okay? All right, thank you.
Judge. E84261 here on behalf of the prosecution,
All right,
who is not present.
who's not present?
I was wondering maybe we could do this without him.
Not for long, we can't.
Your Honor, I know the court has received the
Violation.
bond violation report from community corrections indicating that no tests from therapeutics have been sent over. And defense counsel was kind enough to provide correspondence from therapeutics dated yesterday, indicating that the defendant had been doing some meetings and some other things with therapeutics. But as I looked through that paperwork, I wasn't able to see a record of any drug testing.
Testing.
So I'm not sure If I missed something, it's certainly possible, but I didn't see anything in that correspondence that had that in there.
It's, sorry to interrupt. It's on the top of,
I didn't see.
on the top of the second page, client is in phase 1. He provides UDS, urinary drug sample.
It doesn't include the testing results.
Yeah, that's right. I figured there would be some testing component to it, but I don't know where are the results of those tests?
I don't have the results of the tests. Therapeutics, I understand, is doing the testing and continuing to provide Mr. Jordan with the methadone that he is part of his treatment.
Okay, but are they sending the test to our community corrections?
Unfortunately, it seems that they are not. So I don't have the results, but I do have record that Mr. Jordan is in treatment. He is living homeless, as I was explaining to opposing counsel. He's availed himself of a lot of resources here. There are 2 volunteer social workers from the warming center that asked me to step into the case. I'm on this case pro bono. So Mr. Jordan is in treatment, and I apologize to the court that I don't have the records of the drug, the sort of results of the drug testing, but he's availing himself of treatment. He's in, he's attending these meetings, both individual counseling sessions and group meetings. And the other thing that I think is relevant to the court is Mr. Jordan, this is a case from 2022, 2.5 years ago. And there's a more recent case. He was charged with a misdemeanor, and we resolved that last year with the prosecutor's office dismissing the case pursuant to Mr. Jordan being in treatment, which he's still in treatment. And so it feels a little counterintuitive that we dismissed a more recent case for Mr. Jordan's compliance with treatment, which he's remaining in compliance with. And we've now charged him with a felony from 2.5 years ago. I'd asked the court.
So you should say the prosecutor should not do that kind of thing where, I mean, if they've got to be intuitive, that means everybody should get charged and just go for it. Never mind. Go ahead.
I'm asking that the court, because this case also involves an extremely questionable stop by the police and search of Mr. Jordan as he's walking down the street or jogging down the street. I'm asking that the court, before a warrant is issued on such an old case where there is a questionable, there is, I argue, a Fourth Amendment violation.
Okay, I get that. If he got here, then we could have the hearing on all of that.
Yes.
But he's not here.
Understand, he's ill, he's living homeless, it's been extremely cold outside. He's managed to continue to get himself into treatment. So I'm just asking that the court hold off on a warrant and allow us to litigate the legitimacy of this arrest without a warrant issuing.
Well, I'm going to issue a bench warrant for his failure to appear at this proceeding. And I mean, I might not do that if I had test results coming in, given the circumstances, but I really, none of this really puts a picture together for me of where the defendant is or what he's doing, and certainly not testing. So I'm going to issue a bench warrant. Bond will be set in the amount of $25,000 cash surety. If you locate him and can get him in, there's a warrant recall procedure you can go through on this. That warrant will issue immediately. Thank you.
Yes, sir, that's it for today.
All right, I'm not moving anywhere. 14A stands adjourned. I'm standing right here because I'm tired.
This is the finale. Simpson's courtroom control distilled into one final act. A bench warrant means the system has lost patience. Despite every opportunity for compliance, the defendant failed to appear and failed to test. The defense pleads homelessness, treatment, and illness, but the judge draws a hard line. It's not heartless. It's procedural justice protecting institutional credibility. For the viewer, this is the moral core of the courtroom. Leniency ends where accountability begins. Simpson issues the warrant, cash bond set at $25,000, both a deterrent and a message. The case closes with the judge unmoved, the defense subdued and order restored. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.